be aware of that. The recording will stop at the point at which the questions and answers start. That's expected to last 10 to 15 minutes of the talk. Feel free to put in questions throughout the talk in the chat, but if people can please keep microphones and video off during the main talk, and obviously feel free to put them on at the end for questions. Okay. So people who've been to previous talks aware of this, but just a little on Withers and Rogers. We originally owned a UK firm, but these days also based in France and Germany. And we've highlighted there 3 of our particular offices in Munich, Paris and London. And the reason for that is that Munich and Paris are set to be the 2 most important venues for the new Unified Patent Court, whilst London is expected to be the most important court going forward that's outside the jurisdiction of the UPC. And we're present in all 3 of those locations. Talk today will primarily be by my colleague Dave Croston and Joanna Thurston. My name is Russell Barton. I'm a partner with electronics and physics and software background. Dave is from an engineering background with he does almost as much litigation as he does pre-grant prosecution, mostly in the English courts, particularly before the Intellectual Property Enterprise Court, which actually has some similarities in procedure with the UPC. And Joe Thurston is from a life sciences and chemistry background. Okay, so as I said, today we'll have a brief recap of the system. We don't want to repeat too much for those of you that have been in previous sessions, which I should say are recordings are available. I believe in the invitation, people don't know where to find them, please let us know and we can send those on, which go into some of the decisions and strategies in more depth. Today, we're mostly talking about actually implementing decisions, both around unitary patents and something called the opt-out, both of which we're expecting to be available in just 6 weeks' time. And this is what we call the sunrise period. So today, we're primarily concentrating on the first actions that would be possible to take under this new system. And so for that first recap, I hand over to Joe.
Hello, everybody. So, start a brief reminder of where we are now and what actions will need to be taken in the next few weeks to take full advantage of the changes. Next slide, please. So, we know that the European Patent Office, the EPO, is a single patent office that deals with the filing and then prosecutions of patents, and it can cover up to 39 member states of the European Patent Convention. The European Patent Convention is not an EU institution, but all EU member states are also members of the EPC and so can be subject to European patent. As you also probably know, a European patent is examined at the EPO as a single procedure, and when the patentable subject matter is agreed, the notice of allowance, which we also very commonly refer to as the communication under Rule 71(3), issues, we complete a central grant process, and then within 3 months, we have to select the countries of interest and bring the patent into force in those countries. The process that we call validation. As mentioned, you can validate in each EU member state and in an initial 12. And the validations create a bundle of separate, independent patent rights, which are kept in force and, importantly, for the purposes of the changes, litigated independently of one another. Next slide, please. Moving to the future, the unitary patent, or more correctly, patent with unitary effect, is a new patent right. And it arises from an EU initiative, so it can only cover EU member states, which means it can't extend to the 12 EPC member states that aren't in the EU. And these include, importantly from my personal perspective, the UK, but also states such as Norway and Switzerland. The unitary patent will be accompanied by a new patent court, the Unified Patent Court, or UPC. And the UPC will be the only court that's able to deal with matters relating to infringement and validity of unitary patents. Now, Ultimately, all patents that are granted by the EPO, to the extent that those patents cover unitary patent member states, will be litigated at the Unified Patent Court. Whether they're a unitary patent or whether they're traditional EP bundles of national rights, the type of validation that we're familiar with. But to be clear, you only validate in non-member states. So for instance, you happen to only be interested in Norway and the UK. The Unified Patent Court would have no jurisdiction. It will be possible for an initial period for traditionally validated European patents to opt out of the system. You could think of this as choosing the exclusive jurisdiction of the national courts. That time period will be for at least 7 years. Now, this applies to your existing granted portfolio and to any future applications that grant and are traditionally validated. And Dave will provide you with a reminder of the issues around this opt-out provision later in the presentation. Next slide, please. So just to briefly summary, what is this right? Well, the unitary patent is a single right which has the potential to cover most of the EU. And as a single right, it must be assigned as a whole, but it can be licensed on a country-by-country basis. At this stage, it can protect the 17 countries listed here and will cover more as more EU member states ratify the legislation. If you want protection in countries other than this initial 17, you can either opt for traditional validations, do exactly what we've always done, or you can take a blended approach of seeking a unitary patent with traditional validations added onto that for those countries that are outside the system. And why do we care? Well, because it can potentially cover a huge market. With the current 17 member states, that's more than 300 million people. So the influence of this is potentially massive. Next slide, please. And this is how the timeline currently looks. So to dial back a little bit, as of the 18th of January this year, Austria ratified the legislation. And so everything was in place except the final step, which is the ratification of the legislation by Germany. Austrian ratification effectively allowed the setup period to commence. Once Germany ratify, the system will come into force on the first day of the 4th month following ratification. And because German ratification will trigger a 4-month deadline for the system becoming operational, Germany have intentionally delayed ratification until preparations were sufficiently far advanced that we knew that the court could operate within that 4-month window that they were going to create. This final step is expected in late December, and this will trigger the sunrise period for the Unified Patent Court. Now, it's been announced by the preparatory committee that the system is expected to become operational on the 1st of April 2023. That's the key date, 1st of April next year, with a sunrise period commencing on the 1st of January. As a result of this, the EPO have announced that regardless of whether German ratification happens as planned towards the end of December, they will commence the sunrise period as it applies to their processes on the 1st of January. As such, both sunrise periods are expected to start on the same day, which makes things simpler for us. But the UPC sunrise period does remain linked to German ratification happening. Next slide, please. So we've referred to the sunrise period numerous times in earlier presentations, and I'm using the word in a very offhand manner here. What impact does this actually have? Well, it's going to be the first time that we know with absolute certainty when the go live date will be. We confidently expect this to be the 1st of April 2023. But I think anybody with a patent attorney would say it was certainly going to be the 1st of April 2023, but it's not definite yet. At this point, we firstly can act on opt-outs. So bulk opting out of your existing granted portfolio becomes possible at this stage. We can also start to file requests for unitary patents, although the rule is that you can only obtain a unitary patent for applications which grant once the system is in force. so on or after the 1st of April. And for this reason, requests for unitary patents filed in the sunrise period will generally be accompanied by requests for deferral of grant. Now, requests for grant deferral will result in grant on the first day that the unitary patent goes live, whenever that is, but we believe 1st of April. And the intention is that it prevents accidental grant of your patent before the go live date. Now, they'll usually accompany one another, request for grant deferral and request for unitary effect. It is possible to request the delay and then not proceed to request unitary effect. But if we want a unitary patent, even if that decision is made quite close to the commencement date, quite close to the go live date, we'd always advise accompanying this with a request for deferral. Next slide, please. And what will the procedure look like? Well, pre-grant, there's going to be no procedural difference at all. This is a post-grant change. Post-grant, if you'd like a unitary patent, we request what we call unitary effect at the EPO within 1 month of the grant date. And that's important because this is much, much tighter than the 3-month validation period that we're used to. And this 1-month deadline can't be extended and it can't be further processed. As a result of this shorter deadline, decisions around validations are going to need to be made much sooner. And ideally, instructions provided when you're providing us with instructions for response to the 71.3. And where we are in terms of the start of the sunrise period, for some of you, that could be next week. So, as mentioned, any application that's pending at the go live date could become a unitary patent. And if the preparatory committee stick to the 1 April go live date, then 71.3s that were received as early as August will have the option to become unitary patents if grant is deferred. And for earlier pending notice of allowance, we can use delaying mechanisms to delay grant for long enough to open this as an option for you. Finally, as mentioned earlier, we can take a blended approach. You can't double up on protection by validating in, for instance, France through traditional mechanisms and then also seeking unitary effect, which would create a unitary patent covering France. But let's say you're looking for protection in France, Germany, the UK and Spain. You could validate in all 4 countries exactly as we always have done using existing mechanisms. Or you could validate in the UK and Spain, which are outside the system, and then seek EU unitary effect to provide your protection in France and Germany and get 15 bonus countries along with that. Next slide, please. Now, as I've already said, this is a post-grant change, but completely for the avoidance of doubt. The filing fee, prosecution costs and grant fees at the EPO are the same as they've always been. There's going to be no registration or validation fee either levied by the EPO for the unitary patent requests. So that leaves us with, from a costs perspective at least, 2 factors to consider when whether deciding to seek a unitary patent or to validate traditionally. The first is that post-grant translations must be provided, and I'll talk about those in the next slide. The second is, like traditional validations and patents throughout the world, renewal fees, annuities, must be paid every year to keep the unitary patent in force. Next slide, please. And just to remind you briefly about the translations, these translations must be filed with the request for unitary effect, so with this short 1-month deadline after grant. And this is going to be a requirement for at least 6 years and possibly for the first 12 years of the system. And the point of this is to fulfil the requirement that the unitary patent be available in the national language of each member state. Ultimately, the aim is to rely on machine translations, but the EPO needs to build confidence in that system. And until they have that, translations are going to be required. And the translation that you need depends on the language that the application was prosecuted in through the EPO. So if proceedings before the EPO are in French or German, you need to translate the application into English. If proceedings were in English, all you need to do is translate into any other official language of the Union. And now, I'll pass over to Dave to remind you about the Unified Court and the decisions that we need to make in that regard.
Thanks, Joe. So yes, the Unified Patent Court is really the culmination of the European Patent Project, a single court in which eventually all patents granted by the EPO will be litigated for the member states. And just to be clear, I think Joe has already done this disambiguation, but when we say member states in this talk, we're normally talking about member states of the Unified Patent Court, member states of the unitary patent. It is obviously going to be a brand new court, but recently we've seen the identities of the judges that have been hired to populate the court, and they are experienced intellectual property judges from around Europe. So we hope that that will bolster market confidence in the court. And of course, its purpose is to create a single point of enforcement, and on the flip side, a single point of revocation for patents in Europe. Next slide, please. So when the court was being mooted, discussed, created, there was an element of market nervousness around the idea that a Europe-wide right could be litigated in a brand new court. And so one of the safeguards that was built into the system was this opt-out, which is a transitional measure allowing people to keep their existing European patent portfolio and in the future traditional bundle European patents out of the jurisdiction of the court for a limited period of time. And as you can see there, the initial idea is that that period will be the first 7 years of the court, can be extended on review to 14 years, and the opt-out can be affected in relation to your existing European patent portfolio and any pending European patent rights, if you choose to do that. If you, just to be clear, if you're electing a unitary patent, you are choosing to litigate at the UPC. That is your only option in those circumstances. That is a choice you're making when you elect for unitary effect. If you want to retain the choice between the Unified Patent Court and the national courts, then you'd pursue a traditional bundle European patent. And then you would decide whether or not you were going to apply an opt-out to that traditional bundle patent. All that opt-out does is prevent third parties from commencing actions in relation to those opted out patents in the UPC. It provides the proprietor with a small element of control, but it's not complete. For example, if a third party were to take action against an opted out bundle patent, that would lock that patent out of the jurisdiction of the UPC. You would not be able to withdraw the opt-out in that case, and you'd be stuck out of the system. So a small element of control, but not complete control. Next slide, please. So Joe's already talked about the sunrise period, and she's made the point that there are really technically 2 sunrise periods, but for these purposes, we just simply talk about sunrise period. There is a strong expectation that that will commence on the 1st of January, and we have a high degree of certainty in relation to that date now. I'm not going to get into the technicalities of why there are technically two sunrise periods, other than just to say that there are 2 different institutions that that sunrise period applies to. And the first is the UPC, And one of the actions that can be taken within the sunrise period is to register opt-outs at the UPC registry. And then the other institution is the European Patent Office. And within the sunrise period, the EPO is offering, as Joe has already described, a scheme whereby pending European patent applications which are approaching grant, the grant of those applications can be deferred until the commencement date of the UP system, allowing people to take advantage of the unitary patent if they so desire. And also at the same time, unitary patent requests can also be filed. Now, whilst unitary patent requests can't be actioned until the actual go live date, the 1st of April 2023, some of the work that is involved can be done beforehand. Next slide, please. So we've seen this slide before, but what we've put on there is this period in relation to what we call the 71.3, the EPO notice of allowance. As you most likely know, and as Joe's just briefly covered previously, the issue of the notice of allowance requires approval of the text for grant, payment of the grant and printing fees, and submission of claims translation centrally at the EPO in order to move that case forward in the grant process. And those communications have a 4-month deadline for response. And of course, we still have our famous 10-day postal delay period. So the reason that we have this date of the 14th of August on this slide is that applications which have received a Rule 71.3 communication on or after the 14th of August, the deadline for attending to those things I just described will fall into a period which will take that deadline into the sunrise period, allowing applicants to take advantage of the EPO deferral scheme. Any 71.3 issued before that date will require some other action in order to delay the response date to take it past the 1st of January 2023. And then the reason why it's the 14th of August, as people are scratching their heads, is that the EPO is closed from the 24th of December until the 1st of January, reopening on the 2nd of January. And so any deadline falling in that period will carry forward until the first business day after it reopens, which will be the 2nd of January. And so things that fall in that window will be able to be actioned when the EPO opens again in the new year. And then the other thing to mention in relation to this particular process, particularly for cases where you've already received the Rule 71.3 communication, if you're considering taking advantage of this deferral, it's absolutely essential that you do not approve the text and move the process forward, because approval of the text closes off the unitary option. So please do bear that in mind. Next slide, please. This is a tremendously complicated slide, but fortunately you don't really need to look at it at all. We put it there just to set out why we have a high confidence level in relation to the dates that we're talking about, and that is that these are the tasks that have to be completed in order for the unitary system to be put into effect. And what we know is that all of the tasks on the left-hand side of this chart have been completed. So it gives us a high level of confidence that the whole project is moving forward in a timely fashion and that everything will be completed correctly. Next slide, please. So I'm just going to summarize the decisions that you need to be making now or may already have made and communicate to us, these are really in time order priority. So, as I've just covered, one of the things that we need to know as soon as possible is whether you are interested in obtaining a unitary patent in relation to cases where the communication under Rule 71.3 has already been issued. So the case has been allowed, but we haven't yet moved the case through the grant process. And in particular, those cases where the deadline for responding to the communication under Rule 71.3 falls before the 23rd of December, because those are cases where we will need to take some other action to delay those dates until we get into that post 1st of January period. And if you're struggling with the questions of the strategy around unitary, I'll just commend the cost calculator tool that's linked in the presentation. That is a tool that you can access via that link, and it allows you to input really quite sophisticated country validation and renewal strategies, and it will tell you in today's money whether it will be more or less expensive to pursue a unitary patent based on whatever scenario you want to put in there by way of country filings and so on. Then the second most important thing from a kind of priority point of view that we need to know is whether or not you are intending to opt out existing European patents from the jurisdiction of the court. It's not as urgent as the first thing, but those opt-outs really ought to be registered before the commencement date of the court. Otherwise, you're exposing them to the risk that someone pulls them into the Unified Patent Court by commencing proceedings in the court in relation to those cases. So those opt-outs really need to be registered within the sunrise period, and the sooner we know about it, the better. Then the last two bullets on this slide are really for a bit further into the future. These are the kind of day-to-day decisions that will be made when the system is up and running, and that is, are you intending to use unitary patent for an application that is pending? And if you're not going to pursue unitary patent, are you intending to opt the eventually granted patent out of the jurisdiction of the court? Because those opt-outs can be submitted while the application is pending. Next slide then, thank you.
I was just going to mention briefly.
Throwing back. Yeah, sorry, Russ, go ahead.
I was just going to mention briefly, Dave, just in case anyone was interested in that cost calculator tool, just emphasize, of course, it is rough estimates, which is all you should need, because if it's very close between the UP and the traditional route, then and you're not bothered about the court, you're probably going to go for the UP. But sometimes it isn't close. The reason it's only an estimate is firstly because we can't predict the future and the future costs completely. Secondly, because its trial also build in service charges, including what annuity renewal fee payment will be, the service charge to the company, and also service charges for validations, which obviously vary considerably across the industry. So just to put that caveat, of course, it won't give the exact numbers, but it should give you the idea of whether it makes sense for your business.
I think at this point I'm handing back to Joe.
You are indeed. Thank you very much. So we've reminded you of the changes that are nearly upon us. How do we start to put those decisions into effect? Now, I'm focusing on unitary patents. So next slide, please. First up, I want to be clear that you may have decided that unitary patents aren't of interest to you. If that's the case, not entirely sure why you're on this call, and you're probably not here. However, if you're not interested in unitary patents, very little changes. We'll continue to handle your validations as we always have. The unitary patent is simply an additional choice, not a replacement for the existing system. However, you're here, so let's assume you are interested in obtaining unitary patents. If you have cases that are in the allowance stage now, such that we'd be actioning a response to the notice of allowance during the sunrise period, and so before the 1st of April 2023. What we would like from you as soon as possible, and we've alluded to this already, is early instructions so that we can request deferral and delay grant. As mentioned by Dave, there's going to be a small number of Rule 71.3 communications where a response falls due after ratification, but while the EPO are closed for the festive season, so that window 24th of December through 1 January. And we would have to request unitary effect on the 2nd of January when the office opens again. So for those cases, it'd be good to either decide early that you're not going to rely entirely on this single date and perhaps agree a plan to further process, take the extension, or to provide instructions of in good time so that we're ready to take action on that date. Ideally, for other cases where we're still in the allowance stage now, but the timing's slightly less critical, we'd like to have instructions in place to allow for simultaneous filing of the request for deferral and approval of the text for grant. And we've already suggested this, I'm just reiterating really, it's critical that we have instructions to defer before we approve. If we approve the text without the request to defer, we're playing Russian roulette with the EPO's grant phase processing. And as those of you who worked with us for years know, because of our divisional practice, we cannot control when things are going to go to grant. For the avoidance of doubt, should you positively instruct that you want us to obtain a unitary patent for a case where we need to request deferral in order to achieve that, we will automatically request deferral. The other thing we need is instructions regarding translations. So I've discussed the need to file a translation as part of the request for unitary effect. And we need to know if this will be supplied by you or prepared by us. This is real practicalities we're talking about now. Now, obviously, if you're a direct client, we've handled your global prosecution, we should have a reasonably good idea of how best to cost effectively deal with the translation requirement, and we'll work with you to come up with the most cost effective plan. But if we're your European counsel, we're that little bit further away from the applicant, we'll need more information from you. So provide the translation. As a starting point, we intend to use the type of translation that we're currently using for validations. Although the law for this is worded such that the quality of the translation seems to be less important than is the case for national validations. So it's possible our policy will change over time on this. Key at this stage is we're looking for ways to save costs by looking for overlap in the translation languages, which is something we're all familiar with from dealing with large PCT filing programs. So to take a very easy example, the application's in English, so all we need to do is file a translation into another EU member state language. We'd ask you to let us know if there's a pre-existing translation that can be used. So Spanish is a very easy example. Is there an existing Mexican filing such that we can take the bulk of that and simply align it with the exact wording that's been accepted for grant at the EPO? Another way we could double up on our Spanish translations is if we plan to validate in Spain. They require a full translation of the application. We require a full translation of the application to supply our request for unitary effect. We can make use of the same document. In terms of process, if you've got the translation ready, nice and early, which is preferable because we're expecting a bit of a rush on this, and you instruct us in good time to go ahead, we'll file the translation with the request for unitary effect during the sunrise period. It's all done and dusted. But you might not have the translation. There might be reasons why you need to delay this. And as we've already suggested, if that's the case, we can respond to the 71.3 with a request for deferral such that the application will grant on the 1st of April. We can then make the request for unitary effect within the 1 month deadline that we keep talking about, which here would be the 1st of May. So ideally, we'd get it all done and dusted in the sunrise period. We're expecting translators to be pretty busy in April next year. But if we can't do that for any reason, the absolute deadline, if we've requested deferral on something, would be the 1st of May. Next slide, please. And with regard to filling in the necessary form, Having just prosecuted the application, we expect to have a pretty good idea of most of the information that needs to go on the form. It'll either be on our records or we can extract it easily from the EPO register. That's fine. There are two things we'll need. One issue, and it's one that for many of you, it won't be a critical decision, but it's there on the form, is whether to identify a non-principal place of business within the EU. And this is something that Russell has some thoughts on, so I'll pass over to him to discuss this point.
Yeah, the main thing to say is this doesn't apply to all applicants, and the ones it does apply to, it's a niche issue, which is unlikely to be worthy of much consideration. So for applications that have already filed, the register will already say where the principal place of business was at the time of filing the application. And that normally can't be changed. And if that principal place of business falls within any of the UP countries, say it's an address in Germany, then this option doesn't come into effect at all. So the principal place of business that's listed will determine the national law used to for the treatment of the patent as an object of property. If that isn't the case, so the principal place of business is outside the UP countries, so it could be in the UK, it could be in the US, it could be in Japan, then obviously that doesn't determine. The default will be Germany. However, if the applicant did have some other place of business within those countries, so a subsidiary, retail outlets, almost anything really, then they can choose to put that country down the register, that place of business address, and that country will then determine the national law we use as an object of property. However, the reason this is niche is, does that matter? Firstly, the German law is pretty predictable and pretty good on this. We obviously have German practitioners at Woods and Rogers, so we're comfortable with that German law. The other thing is, it's very rarely actually making a difference to the patent. So the one area I'd say that it does affect is if there are joint applicants. So that's something we generally discourage, but if you're in a situation where there are joint applicants, the national law as to the rights of the two joint owners does vary across the different UP countries, and therefore this issue may actually be important. Outside of that niche situation, probably doesn't matter. One thing it affects theoretically is the requirements needed for an assignment to be legally effective. So that sounds like it could be a reasonably big deal in terms of making your assignments easy or hard to obtain. However, you're going to want to record those on the register. And to record on the register, you have to go through the EPO, and the EPO rules on this say that the normal EPO rules on assignments apply. So regardless of which nation is chosen, you're still going to have to deal with the same EPO laws about which treatments of electronic signature, authorization to sign, etc. So even on that assignment issue, this is unlikely to matter. But it is a matter. If there's reasons that it's considered it might be important, we're happy to look at the specifics. But for most clients, I'd say it's not going to matter. Back to you, Jo.
Thanks. The other thing that appears on the form, and so it would help us to know, is if the applicant is an SME, natural person, non-profit organisation or university. Now, this is because the EPO have included an optional box, and I stress that it's optional, for information gathering purposes. They're curious as to who's making use of the unitary patent system. But that box asks us if the applicant falls in any one of these categories. It's not something we'd ever chase you for. It's an optional entry, and we propose to tick the box where it's immediately apparent which category the applicant falls into, if any of them, because there isn't a large entity option, for instance, and to just leave it blank if we're uncertain, and there'll be no penalty for doing that. Next slide, please. And then moving to the longer term, so post 1st of April, the system's up and running. We'll be working to this very strict short deadline for requesting unitary patents. As you know, the deadline can't be extended, and it's made tougher by the need to file a translation. As such, through necessity, we'll be pushing you for earlier instructions around validations, such that if you'd like a unitary patent, we have time to accommodate that within the first month post-grant. Many of our clients plan to give us their accompanying validation instructions at the same time. So if they'd like a unitary patent, give us instructions for that, and tell us which non-member states they're interested in as well. So they instruct the entire programme when instructing the notice of allowance. And this is partly for efficiency and partly to allow us to look for potential overlaps in translation needs, which may help us save you money. However, as has always been the case, we're capable of addressing validation instructions at a later stage within the familiar 3-month deadline for those. And now I'll hand over to Dave to discuss how we'll action instructions to affect the other key process that becomes available during the sunrise period, the opt-out.
Thank you, Joe. Sorry, for those people who don't know, I'm suffering from a cold at the moment, so I've been going off camera so I can cough, and hoping that I don't cough in the middle of my bit. Anyway, yes, what I'm going to cover in this slide is the issues around opt-outs, and they've been much discussed. They are fraught with administrative issues in order to register correctly. In particular, they need to be registered on behalf of and by all of the correct current owners of the relevant right, relevant patent. And that in itself can be rather problematic. Even ourselves prosecuting patent applications, we may actually not know the fate of one of these validated countries, country patents. It may have been assigned to somebody else. It's actually quite difficult to know. And the other problem is this is perceived in the market really as an administrative step, but there is potentially significant consequences of a failed opt-out. So they're just things to bear in mind in relation to opt-outs. There are a number of service providers offering opt-out services, bulk opt-out services. You will find that they are seeking to place the liability for the accuracy of the information on which the opt-out is based onto the instructing proprietor. You may find that you are required to sign a declaration stating that the information is correct and that you are authorized to instruct the opt-outs. Next slide, please. So this slide is really just to observe that there is a variety of providers with a corresponding variety of prices and service levels in relation to the registration of opt-outs, and that corresponding risk with a kind of bargain basement approach that things may not be subject to the appropriate level of due diligence, and so consequently the risk of error. And now all of this may be a storm in a teacup. If it turns out that the court is functioning well, that it gains market confidence, then the significance of an opt-out will be lower, and consequently the significance of a failed opt-out or an erroneous opt-out will consequently be lower. It's also noteworthy that it is possible to monitor opt-outs, both of your own portfolio but also of competitors, and that may be useful market information, market intelligence that you could deploy. Next slide, please. And this slide really deals with the future or the ongoing situation. We expect unitary patent election and opt-out decisions to become just a natural part of the normal patent prosecution process. It is, though, typically sensible to leave this decision until later in the application process. I mean, why go on less information? There's no point committing too early. As Joe's already said, we will tend to be asking these questions during the grant process of applications. So on receipt of the communication under Rule 71.3, we'll be asking whether this is going to be a unitary case? If it's not going to be a unitary case, is it going to be a case that you want to opt out of the jurisdiction of the court within that transitional initial 7-year period? And then finally, really just a comment, a tactical comment, why not have the best of both worlds? Have a 1 foot in and 1 foot out of the camp. You could do that by judicious use of divisional applications. So more food for thought there. Okay, I'm passing back to Russ, am I now?
Thanks, Dave and Joe. Really appreciate it. It's going to be a very short summary. So we've always said the forward plan is important. Hopefully most decisions have been made, but if they're not, there's still time. And with the unitary patent, the main thing going forward is going to be that it'll be more important to give the validation instructions earlier than previously. So some applicants have always tended to give validation instructions at the same time as the instruction for approval of the text, whereas others have kind of seen it as 2 steps. Deal with whether you want to go ahead with grant and then deal with validations. But there is, because the unitary patent has a much shorter deadline, it's generally going to be useful to bring that decision early in the process. It's worth emphasising though that whilst our 1-month deadline is very short from grant, the deadline from the Senate 1-3 allowance is still very long. It's typically a good 6-month period between allowance and grant. So you've actually got a lot of time to decide. But it's useful to have all those instructions together. Ideally, certainly the unitary patent we need earlier. It's also good to consider what the full outcome is when making that, when giving the instructions. So, for example, if you are going to validate in UP and Spain, then the Spanish language could be used for both. That's useful to know. Whereas if you didn't know that, maybe a different language would have been used for the unitary patent, and then you'd have to go and get a different translation again for Spain. And then the opt-out, just keep on top of who the owners are, make sure you know that if it's important to you. And as you say, for the bulk opt-out, you'll probably have to sign some form of declaration, even if you're not filing the opt-out yourself. If you file the opt-out yourself, you definitely have to file a declaration. And if you're using a third-party service provider, you probably have to sign some sort of declaration for them to use. And lastly, you consider monitoring your portfolio and others. So you can see what other competitors are doing with opt-outs, but the reason for monitoring your own is just because some people go treat this as a administrative procedure. There could be errors. So, for instance, literally someone puts a typo and the wrong number. If they don't check properly before they sign off, then you may find it's possible that someone else could have opted out of the patents without your consent. And there's a mechanism for undoing that. Okay. I think we can go to questions. We've had at least 2 in the chat, so I'll start with those before asking if there's any more.